And we'll kick off with Senate Bill 96, Senator Mullis.
Thank you, Mr. Chair. It's a pleasure and honor to come before your committee with such distinguished members. I appreciate this. I bring this to you today, Senate Bill 96. It's about part-time solicitors, and what I've found out, there are more part-time solicitors for state courts than there are full-time solicitors in Georgia. And if you can imagine, some of the laws are pretty restrictive about what they're allowed to do outside the criminal element in their court, and this allows them to be able to do more legal practice in their own county. And I've been working with the State Solicitor General's Association. I hope I got that right. And we added an amendment in the Senate side that made them happy, so they're good with it now. Be glad to answer any questions. You see, there's only one line that's been affected, I believe, or in the bottom. I don't have a copy of the bill, but I don't need one.
That's all right. Questions for members of the committee? Mr. Coomer?
Thank you, Mr. Chairman. Mr. Chairman, I've got House Bill 188 in your committee. Have you taken? No, I'm just kidding. Just kidding. Only joking.
I've been waiting for you to hear from you.
No good deed goes unpunished.
We took care of the chairman earlier. I've been waiting to hear from you, Mr.
I'll be there.
We had to go turn back the wire on House Bill 55 or whatever that number was. Yeah. Seems like a year ago now.
I actually do have one question about the bill.
Yes, sir.
It appears that the changes will have the effect of making it so that a solicitor general, part-time solicitor general, will not be able to do any business before the state court other than representing the state. Is that the intended effect?
Yeah, okay. and where they can do other legal business that, for example, let's say, which I can't imagine, but let's say this happens. That Solicitor General prosecutes somebody for a traffic violation, but yet he did such a good job prosecuting him, he now hires him to represent him in Superior Court. You know, without this, that would not be proper. But, you know, the lawyers have a code of ethics that they have to abide by, too, which is very strenuous, and that would cover a lot of things that may be somewhat questionable. But this kind of makes it black and white, too.
Okay, thanks, sir.
Any further questions? Mr. Setzler.
Thank you, Mr. Chair. Senator, is this going to – what effect is this going to have on them being able to practice in a Superior Court? I mean, if you're a solicitor that practices just in the state court, is this going to preclude you from doing any kind of work over in the Superior Court?
No, actually it helps you. It makes it clear that you can. Before that, it was somewhat unclear.
Okay.
So this helps him.
I'm sorry, I stepped in a moment late.
No, that's okay, man. And Representative Setzler, I'm always very respectful of your positional issues, and I'm glad you brought that up. And in fact, I didn't realize this problem. You can imagine in a rural county solicitor, they don't make a lot of money. And being a lawyer, you guys are supposed to be all wealthy, aren't you? Did I miss that?
Only Mr. Coomer.
Actually, Senator, I'm told that as a non-attorney myself, that if there's one attorney in a small town, you starve. 2 attorneys, you do okay. 3 attorneys, you make a fortune. Everyone makes a fortune. I don't know if that's true all across Georgia, but that's
we need to do a study committee to see if that is true.
A wise former Speaker of the House told me that.
Mr. Hightower.
I can appreciate this bill. I'm a prosecutor for 2 city municipalities out where I'm at, and that's not the state court level. If I was a solicitor, then I wouldn't be able to have the position I have now.
Right.
But this problem is also even more widespread in your municipal courts because they really need to have part-time folks. And there's actually, I had to get a legal opinion before I got elected that said I could be a prosecutor in a municipal court and still have my state court position or my legislative position. So this is needed, and I appreciate you doing that.
Thank you. Any further questions from members of the committee? Seeing none, I see no one signed up to speak on SB 96. Is there a representative of the Solicitors Association here?
Mr. Chairman, I'm not here on that. I'm here on behalf of the prosecution committee, and we support Mr. Moss' efforts in this regard. Representative Hightower has highlighted the exact issue you just made, securing, making certain that where there's a local lawyer who wants to be a part-time prosecutor, he's insulated from the claim that he somehow jeopardizes the practice law in the other courts. That's what this does.
Okay. Thank you, Mr. McDade. Seeing no other inquiries, what's the pleasure of the committee? Mr. Coomer moves do pass of SB 96, SB 96, FA/FA/2, second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion, signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And let me know if I can be of any service to your members in the little old committee that I chair.
We appreciate that. Thank you, sir.
And also, Representative Weldon will be handling this bill.
Very well. Thank you. Senator Carter, are you positioned the way you want to be? All right. We'll call SB 134. Senator Carter.
Thank you, Mr. Chairman, members of the committee. I bring before you today Senate Bill 134, a very simple bill, if you will, if there is such a thing. It addresses the definition of prescriber, and it just simply adds, as you will see on line 9, or any other state or territory of the United States. Currently in the state of Georgia, pharmacists fill prescriptions from doctors out of state. We honor those prescriptions. However, it needs to be in the code section, and it's not in the code section now. What it says simply is that we can honor prescriptions from doctors who are licensed in our state but not out of state. This was brought to a head as a result of the Prescription Drug Monitoring Bill. In order to apply for grants and receive grants from the federal government to fund that program, the Prescription Drug Monitoring Program, we have to be able to fill prescriptions for doctors out of state, and it has to be codified in our code. So that's the reason for it, and there are no amendments. I don't know what he's trying to achieve with that, so I'm not going to accept that.
All right, so just to make sure it's clear, that we will not, it's the sponsor's wish to direct focus just to the bill as it passed out of the Senate, LC 410042.
Yes, sir.
Okay, questions from the committee, Mr. Coomer?
Yes, sir. Thank you, Senator, for bringing the bill. When we had the prescription monitoring bill a couple years ago, we put in some pretty stringent requirements that had the effect of preventing the keeper of the record from disclosing those records to, and I'm going to say the state, from disclosing those prescription records to other states, essentially, and to keep a tight rein on those. Does this open a door for our prescription monitoring database to be accessed by other states?
No, sir. Senate Bill 134 does not do that. It may be attempted to be done in another bill, but it is not in this bill.
Okay.
Any other questions from members of the committee? Seeing none, I see no one has signed up to speak on SB 134. Is anyone who wants to be heard on SB 134? Seeing none, what's the pleasure of the committee? Mr. Strickland moves do pass Senate Bill 134, LC 410042. Is there a second? Second by Ms. Mallinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, the motion is adopted.
Thank you, Mr. Chairman.
Thank you, Senator
I'm going to
Carr.
ask Representative Tom Weldon to carry this.
Tom Weldon, thank you.
Thank you.
Let's take a brief pause, and I was remiss in not acknowledging a new member of this committee, Representative Darshan Kendrick. Welcome. We appreciate your being here and look forward to your active service on the committee. We meet generally Mondays and Wednesdays in the afternoon, and look forward to your membership and participation. Yes, ma'am. Welcome. Let's call Senator Hill. Senator Hill, what's your preference? Do you want to do SB 170 or want to do 187 first?
Let's do 187.
187.
Thank you, Mr. Chairman. Good afternoon, committee, and good to see you all once again. Let me bring before you, if I might, Senate Bill 187. I have a proposed amendment as well, which is clarification. You've seen this measure. You do, I believe. It might be brought copies, so it might be handed out. Real simply, this came out of what we all like to see and are encouraged by, and that's our constituents bringing to us great ideas. So my two youngest are in high school in Cobb County, and I had a bunch of high school parents came to me and said, "Did you know what you did?" And so when we passed legislation a year or so back, when we required all this verification for people across the state of Georgia showing residency and citizenship and all that, among other things, what's happened is the Georgia Student Finance Commission has taken upon themselves to start requiring annual tax returns through the federal financial aid document to qualify for the Hope Scholarship, which is a merit-based, not a financial needs-based scholarship. And next year, according to their website, which I've been on, they're going to start requiring that every single year. So your freshman, your sophomore, your junior, your senior in college will have to submit their tax returns to qualify for the Hope Scholarship, not the grants and all the rest of it, which are needs-based, but the merit-based side. Representative Dollar has a similar bill, and I applaud that. And frankly, if you don't care who gets the credit, let's get a good bill passed. And so whichever one moves across first, I would be thrilled to be the Senate sponsor of that bill and sit on. I mean, I really have no dog in the race, but to change the law. So here's what's been going on since background. You go, okay, what about this background on the residency? Well, legislation we passed a few years ago initiated the Board of Regents determining the citizenship and all for Hope Scholars in the first place, and so they've been doing that for like the last 3 years, Board of Regents. So what happened when we passed other legislation, there's no need, the short version is there's no need to determine the residency because the Board of Regents is currently doing that. And so what Senate Bill 187 says is we're exempting that requirement for the Hope Scholars, and that's what this amendment is, because I wanted to make it really, really clear what we're trying to do. Because if you look at the paragraph of Senate Bill 187, it's like, okay, what does all that really mean? Well, what it really means is the proposed amendment, which is they shall not require the submission of the federal free application for federal student, what's the FAFSA form, or federal and state income tax returns as part of the Hope Scholarship. So that's the purpose of the bill. That amendment is not on Representative Dollar's bill, and he's my representative, so we work closely together and be happy to.
Separate, just to make sure it's crystal clear, separate and apart from the amendment itself, forget about the amendment for a second, what would the effect of the bill as written, separate and apart from the amendment, be?
The very same thing, which exempts that out, and Legislative Council told us, and I followed Representative Dollar's lead on the language of 187. It's not different than the House version. We were advised that this language in 187 as it stands would do what we're trying to do. Based on questions on the floor of the Senate, I thought it would be wise to be very clear with directions to the Georgia Student Finance Commission as well as in law that here's what the objective is. Preclude the requirement for the FAFSA, preclude state and federal income tax as part of the requisite eligibility annually for Hope Scholars. We don't need that information about their financial backing to qualify for a 3.0 or 1,200 on your SAT to qualify for the.
All right. So just to be clear, by virtue of adding in the Student Finance Commission, that's for purposes of the Hope Scholarship, correct?
Correct.
And then we're adding, and then the amendment seeks to go ahead and reinforce that. In other words, Georgia Student Finance Commission and the Board of Directors, Georgia Student Finance Authority, will go ahead and set forth regulations as it relates to verification of lawful presence, as it relates to the Hope Scholarship. That will be added to it to reinforce that, or not to reinforce that, but in addition to that, the amendment goes to just making crystal clear that there shall not be a requirement of the submission of the FAFSA form as part of an application for Hope. Is that an accurate statement?
That's exactly what we're trying to do.
Okay. Mr. Setzler.
Thank you, Mr. Chairman. Senator Hill, I get the policy direction, and I strongly support it. I have actually been almost accosted by parents on this issue, and I understand that the clock is ticking. That they've got to submit it by, was it May or June of this year, for kids to qualify for the fall. I just want to understand, being in committee and kind of working through this. I get the amendment. That's clear enough for a guy like me to understand. What I don't understand is perhaps to the chairman's question, lines 12 through 15. How did the language that's inserted there work to accomplish the goal, and how does that fit? Without the code section in front of me, I'm trying to struggle to how that folds together.
I shared with your concerns.
Uh-huh.
This came out of the wisdom out of legislative council at the time, the core bill, to provide that discretion, telling them that if you look at line 3, it says provide exemptions for the board. I wanted to be really clear, to the chairman's point, I wanted to be really clear of what we're asking them to do so they don't have to guess if this bill were to become law. And that's, you can do all these other things that you're doing, and we applaud what you're doing, but we don't want you to require the FAFSA form. We don't want you to get federal and state tax returns. And it's not so bad that we asked for it once. We're asking for it annually. So to qualify as a sophomore, assuming you made the college grades, we look for it again. And to qualify as a junior, we're looking for it again. And it's not the purpose of.
I guess, Mr. Chairman, forgive me for not having brought my laptop in, and or having been able to expound upon this, having done an hour homework on this. I have not done that. How is the subsection D constructed? Just explain to me generally how that works. I'm just trying to get my mind around it.
It gives them that
I don't know
discretion.
if council has it.
It gives them that discretion and says that they're exempt, and I followed the lead of, and I defer to Jill Travis, who we've known each other since law school, and she is, and seriously would. But I followed the lead of Representative Dollar in the language, and if I sought to clarify it because Representative Setzler, I had the very same questions, and I wanted to make sure that anyone looking at this in the future would understand the purpose behind.
Let me try to avoid get some clarity as well. I mean, are we saying here that by virtue of the bill as written, I may be completely off, that the Georgia Student Finance Commission and the Board of Directors of the Georgia Student Finance Authority didn't have a mechanism in place for verification of lawful presence as it related to the Hope Scholarship, and therefore that provision was necessary? Or is that inaccurate?
Restate that, if you would.
So, I mean, by virtue of that language going in, Georgia Student Finance Commission and the Board of Directors, was the need for that for lines 12 to add in lines 12 to 14, and the regulations in line 15, was the need for that? Was it precipitated by a lack of mechanism whereby they would confirm lawful presence? So they didn't have that mechanism or that
My
authority?
understanding is because of the House, it's probably a House bill we passed a few years ago, whether it's House or Senate, not trying to pick on one body to the other, 87. The professional licensing requirements, all the things that are going on at the county level that we're trying to, frankly, clean up. And if you're a citizen, you're born here, and we're not asking for it, you just submit the same thing over and over and over and over again, literally. The Student Finance Commission has advised that they're understanding the best interpretation of House Bill 87 was to require this documentation. That's what I've been advised.
Okay.
So they weren't requiring the FAFSA until, I believe, this year. And now after this year, they're going to require it annually. And that's on their website, too.
Right.
So this measure came because we've already heard from, you've heard my story, I've heard y'all's story about our parents saying, time out. This is merit-based. It's not a financial base. If it's financial based, there's no pushback, but for the merit based, let's change it. So 187 did not ratify a regulatory action. 187 was the attempt to say you're exempt from that, don't do it. The amendment just provides the clarity for what 187 was attempting to do, because I didn't believe, based on the valid questions that you have, and I frankly had too, and listening to the dialogue, make it real simple.
So it was
it
didn't go toward policing on on verifying lawful presence. It went to the repetition of verification,
Correct.
analogous to the licensing fix that we have.
Mr. Chairman?
Supposedly
And
in
I understand
125.
187, if it were to pass, would do what the amendment does. But I would just want to be really.
Okay, let me defer back to Representative Sessler.
I just read subsection D there. What it says, subsection D is verification of citizenship shall not be required for the following. It lists soup kitchens, immunizations. It lists some things. 7 is this post-secondary education, Board of Regents. So to get into a college, there's not a requirement for this verification, or for a public college. But because the Georgia Student Finance Commission was not listed there, then there was this requirement to do it for Hope Scholarship. By putting Georgia Student Finance Commission in this language, you don't have to demonstrate, you don't have to use FAFSA or some equivalent form to do things that are governed under Georgia Student Finance. So by adding Georgia Student Finance to the list of places you don't have to demonstrate citizenship, it allows this to happen. But it sort of happens in the negative.
7 was another exemption of
was a
that
carve-out
requirement
where you don't have
because
to
there are already 6 provisions. 7 is the next carve out, and what the proposed amendment is to add to 7, not make another subsection 8, add to 7 to make it clear.
to reinforce that this
Reinforce what 187 by itself
on the tax returns
will do. Yes, sir.
and the submission of the FAFSA. Okay. Good clarity.
And I don't have my file before me, so I
That's all right.
apologize.
Any further any further questions from members of the committee? Mr. Atwood.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this. I'm trying to recall this out of the cobwebs on House Bill 87. Maybe you can help me with it. Are there other provisions in the law, or let me put it this way, is this bill any way interfering with any prohibition or any enforcement effort of keeping someone here who was here illegally from getting something that they should not otherwise obtain, such as the Hope Scholarship or something like that? That's in no way interferes with that.
No way interferes with any of that. And all it does is provides that clarification. The Board of Regents is already doing what we asked them to start doing 2 or 3 years ago, and by law. And
I didn't recall it doing it, but I just wanted to.
I think what happened was the interpretation became such that they, out of the abundance of caution, potentially, they didn't tell me that, they decided to start doing this. The Student Finance Commission layering on what Board of Regents is already doing. But you've heard the rest of the reasoning behind it. And thanks, Representative Setzler, for grabbing the computer and providing the clarification.
Any further questions from members of the committee? Seeing none, I see no one signed to speak on House Bill 187. Is there anyone who would like to be heard on House Bill 187? I mean, Senate Bill 187, sorry. Seeing none, what's the pleasure of the committee? Yeah. Mr. Setzler moves due pass of Senate Bill 187, LC 286599. Is there a second? Second by Ms. Ballinger. Are there any amendments, Mr. Setzler?
I'd like to offer AM 281240 to provide further clarifying language.
Mr. Setzler offers AM 281240. Any discussion on the amendment? Seeing none, all those in favor of the amendment signify by saying aye. Aye. Opposed? The amendment is adopted. Any further amendments? Seeing none, on the gentleman's motion of due pass now by substitute. Well, Ms. Travis, I guess we can't do it by substitute because that would necessitate a separate, another LC number. By substitute? Okay. Referencing the same LC? Just by substitute. Okay. On the gentleman's underlying motion of due pass now by substitute of SB 187, all in favor say aye. Aye. Opposed? The ayes have and the motion's adopted.
Thank you very much. And if you need me to help coordinate on the
We'll assume
committee sub,
Representative Dollar to go ahead and carry that.
That's correct.
Okay, let's do that. And we'll call Senate Bill 170.
Senate Bill 170 is no stranger to the Capitol. And Chairman, thank you over the years of alerting me to different changes along the way. This bill has been around for a number of years, but it's always passed the Senate, and there's never really been any opposition in the House, but it has become the Chuck E. Cheese bill and all sorts of other pizza flavors.
There was an
Yeah.
orphan posture
Yeah.
in the bill
Yeah.
once or twice, but
The
now we're
background-
glad to go ahead and remedy that wrong.
Thanks so much, and we look forward in the Senate Finance Committee to help not even improve upon what you've done here, but just pass them. The underlying Senate Bill 170 does this. The purpose is to make and strengthen the laws behind medical identity theft and make them identical to financial identity theft. We all see the advertisements about what if you lost your credit card, people stealing your identity and all that. Well, the fastest growing, if you didn't know, the fastest growing type of identity theft is medical identity theft, not the financial side. For example, it's Medicaid fraud. People get your health information. It's losing your wallet. You don't replace your health insurance card. You just get another one, but you change the number on your driver's license or change the number on your credit card. And there's a whole ring that goes around of stealing all that information, whether it's the health insurance information to file false claims against your health insurance records, or stealing your medical identity, because there's a medical a bank, if you will, that collects all this information about adverse claims and such, and it has a substantial. Thank you. And so that's the purpose, is to delineate what types of documents are illegal, and then to actually make the penalty identical to the financial identity theft. When I walked in, and also Ms. Travis gave me a copy of the substitute, and I'd like to hear what's being intended by the substitute, because I haven't looked through it, other than it looks like it's stripping out the penalties. And but I've only glanced at it, so.
Just from the review, and obviously we're trying to move in an expeditious manner on this, I know that this, and I'll give Representative Ramsey some fair warning. This is a substitute that came out of Representative Ramsey's subcommittee during previous consideration of the bill. That was, Ms. Travis reminded me of that yesterday. So we had the substitute put in as, frankly, an option for consideration, given the fact that it had gone through that process previously. Candidly, I cannot speak to the merits or demerits or the reasoning of the substitute. Let me ask Ms. Travis. I know that there was part of it was drafting, but I want to just make sure that we have a clear sense of, and the chair is not offering the substitute as an alternative. It's just a piece of work that was done in conjunction with this issue previously, which does not mean it's necessarily that which we will consider. But let me ask Ms. Travis just if you could add some clarity to the rationale there.
Yeah, so Senate Bill 170 is the same as Senate Bill 19
from last term.
from last term.
Correct. And it's probably the same as Senate Bill something from the prior.
Right.
And so when Senate Bill 19 came to this committee in the 2011, it produced a substitute, which is all except for at the top where it says Senate Bill 170, the same as what is before you now. That's just the numbers have changed because the bill has changed. So the difference between the introduced version of the Senate Bill 170 versus the substitute is that it just is using all of the existing language of the article having to do with identity fraud without having to go into more of the minutia. It's just changing the definitions to include it. It keeps all the same penalties the same as what's already in there. So in other words, if you're a victim of identity fraud, whether the record was your health record or your mother's maiden name or your checking account number or your credit card number, all of the penalties and everything remains the same.
So what it's essentially doing is we're adding healthcare records as per the author's intent, but we're keeping the same penalty provisions under the same general article. Right. Or at least that's what the substitute.
If I may have a question.
Absolutely.
What I don't, because I don't have the statute in front of me. My recollection, this goes back a few years, and so it's kind of off the top of my head. My recollection is that the penalties for the medical identity theft was different than the financial crime, financial fraud. And one of my purposes was to make them identical so that someone wouldn't say, "Oh, I got to pay $100 when I steal someone's health insurance information, but I'm going to jail for, or let me go steal the health insurance stuff." My desire was to make those
Conformity.
identical, conforming penalties. And if this does that, the other reason for potentially the substitute, just reading between the lines, is you're pulling out all these Title 16 titles, which I'm presuming, since I wasn't a part of presuming that gave provided the opportunity for a vehicle to create the Chuck E. Cheese bill and others, that I had 6 or 8 personal threats that were extensive enough to refer to the Georgia Bureau of Investigation against my family and my wife and my children, of a bill that only had this same bill number and your name on it. But my wife got over that after reading the emails before I saw them. That's been 2 or 3 years. But if we're doing making the same penalties as financial crimes, then I would fully support the substitute.
Let me defer back to ask counsel then that we're.
There was no change in, if you look at page 6 of the original bill, there is no change in the penalty.
Okay. So what I'm seeing in the substitute that we have in front of us, LC 295635S, or how I characterize it, is it does adhere to it conforms to other penalty provisions for other financial crime as per the author's intent that he's just stated. It's just a cleaner way of doing it in the substitute that we have before us. Is that an accurate statement?
Sounds like it. Yeah, I just
Okay.
want to be clear.
I just want to make sure we're
frankly,
clear on that.
After 3 years, I've never, frankly, read the bill again because I knew it pretty well off the top of my head. So.
Okay. But I just want to make sure it achieves the author's intent.
And that's correct.
Okay.
And I just wanted to ask the question so I could hear the answer. And with that,
Sure.
I think the substitute's a great substitute. So.
Okay.
Thank you.
Questions from members of the committee? Thank you to Ms. Travis. Questions from members of the committee? Ms. Kendrick.
Thank you, Mr. Chairman. So what is the current status of medical identity theft right now? I mean, what happens right now without this bill passing if somebody tries to use that information?
Currently, if someone tries to steal the information, it's not clear. If you just referring you to the definition of healthcare records, my recollection is that it's not clearly defined in the code, as well as, for instance, we added line 47, veteran and military medical information numbers. There's a growing number of crimes committed against our military for the reasons, obviously, that more of them have been deployed and active than in the last 10 years or so than ever before. So the purpose was to add additional clarification to the records, prescriptions, hospital charts, etc., which was not in the law at the time, or prior to the passage of this legislation. And we may have cleaned up along the way some of the penalties over the last few years, and so initially at one point, I don't know if we've done that back 2 or 3 years ago.
Ms. Kendrick, do you have follow-up?
I do, and maybe I'm missing it. Why is it that medical identity is different than, say, for example, you have on lines 20 through 22, it's the same definition for lines 50 through 52. So I'm trying to understand what's the purpose of creating a whole separate category for medical identity theft as opposed to
Which lines again? 'Cause
20 through 22. Am I wrong?
that's current law, I believe, and not changed. Is that?
She's looking at that's one of the reasons why I did this sub, is to clean all that up.
The reason we did the sub is because it cleaned all that up.
So what?
We've been doing this for a long time since law school. It's been longer for me than it is for Ms. Travis, but
Are you working from the sub, Ms. Kendrick? Okay.
Sorry.
That's all right.
there were some cleanups that needed to be done, and there were inconsistencies between the two types of fraud, and that's what also precipitated the legislation a few years ago.
Mr. Coomer? Any further questions from members of the committee? Seeing none, I see no one else signed up to speak on SB 170. Is there anyone in the audience who'd like to be recognized to be heard on SB 170? Seeing none, what's the pleasure of the committee? Mr. Atwood moves to pass of SB 170 by substitute LC 295635S, second by Mr. Gravely. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Senator.
Thanks, Mr. Chairman.
Yes, sir.
I have not selected a recommended member to carry it, but to the extent that one of the members of the committee, potentially Representative Gravely or somebody else, not putting him on the spot, I haven't talked to him yet.
We'll figure it out.
Love to. Thank you very much.
If you have a specific recommendation, please let Ms. Bazemore know sooner rather than later. If not, we'll figure someone out.
Okay. Thank you
Okay.
very much.
Thank you.
Have a good afternoon.
Call SB 204, Senator Cowser.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. This is a bill brought to me by the State Bar of Georgia and actually requested by their appellate practice section. It's to clean up kind of a little overbroad language that we had a few years ago dealing with direct appeals. Code Section 5634 provides that you can have a direct appeal of all judgments or orders in a child custody case. And what we did back when we passed that bill is we had five deadly words. We said including but not limited to. And then we listed basically orders awarding or refusing to change child custody or holding somebody in contempt for something child custody related, which could have been child support, etc. Well, those words included but not limited to opened it up to any order in a domestic case, basically. And that could have been an order by a judge requiring discovery or to produce documents or any ancillary type order that did not deal directly with child custody or child support. So the Court of Appeals is getting flooded with appeals that are direct appeals rather than going through the discretionary appeal process where you have to get a certificate of immediate review, etc. And this would help, I believe, go back to our original intent, that if there's an order that deals with child custody or child support, either modifying it or changing it or refusing to do so, that should be directly appealable. But any other ancillary orders in a domestic case should fall under the discretionary appeal procedures. I know Judge McFadden is here today. He may have signed up to speak, but he could probably speak more directly to some of the problems that the court is having there. The only other change was adding the word modifying child custody. We felt like that also clarified the types of orders that should be directly appealable. I'll be happy to answer any questions, Mr. Chairman.
Questions for the author? Mr. Strickland.
Thank you, Mr. Chairman. Do you know if the word child custody includes visitation as well?
It does.
Okay, I know you have cases where you have grandparents going for visitation. I want to make sure that would also be considered custody as well.
Visitation is an element of custody.
Okay,
Yes.
thank you.
Any further questions for the author? Ms. Kendrick. Oh, I'm sorry. Is it Ms. Kendrick?
Yes.
Yep. Go ahead.
Thank you. I don't go to court much, although I am an attorney, so maybe this is just a non-litigator question, but what's going to happen to the cases that are already in appeal?
They're still directly appealable if they're already on appeal. They'll be heard.
Okay.
Yeah, we can't make it effective retroactively, so we'll have to live with that. I thank God I don't do domestic work any longer myself either. That's where my gray hair came from.
About that. Mr. Setzler.
Thank you, Mr. Chairman. What's the process if the point that's being appealed doesn't fall into this definition? What's the process for them then?
It's called a discretionary appeal procedure, and if it's in the middle of the case before a final judgment, you have to petition the judge and ask for what's known as a certificate of immediate review, and then send it up to the Court of Appeals, and they can accept it or not. But the trial judge has to agree that it's a significant enough issue to delay that case, and he can permit it to be appealed in midstream, so to speak, interlocutory, sometimes we'll call that, before it's a final judgment. That doesn't bind the Court of Appeals to accept the appeal. They have to decide it's a significant enough issue
before they do. But there is that's the process if it's not a final order. Other than now, any order dealing with rejecting, modifying, changing child custody is directly appealable and will remain directly appealable under this statute. It's just limited to those type of issues instead of all other orders.
What kinds of circumstances fall within the definition of what's directly appealable, and what things specifically lie outside of that? Could you give us some?
Yeah, I mean, this bill tells you. This provides that if it's a judgment or an order of the court in a child custody case that deals with either awarding child custody, refusing to change child custody, or do change child custody, modifying it in some way, and of course that includes visitation, as we discussed, and I believe it also includes child support in that case, or holding a person in contempt of any of these type of orders. So let's say a parent prohibits visitation. You know, there's an order that told them that you get the kid at Christmas, or you got to turn them over at certain times, and they refuse to do that, and they're held in contempt for violating that court's order. They can directly appeal that as well. But anyway, this lays out those types of orders in a case that are directly appealable.
What would not be directly appealable based on the way you've defined this more clearly?
The example that I think of is, let's say you filed a request to produce documents on me. You wanted all my tax returns, all my bank account statements and credit card bills, and I just didn't do that. If the court had ordered me to do it, and maybe I didn't think that was appropriate or whatever, I could appeal that directly right now. And that's not what we want to bog the Court of Appeals in, with things that aren't the essential issue of child custody and child support, or the terms and conditions of that.
I asked the question, Mr. Chairman, because for people who don't practice in this area, it's hard to. It's a terribly, terribly important part of law. It's not something that many folks have specific experience with, particularly non-attorneys or even attorneys that don't practice in this area. So we're trying to get your mind around what we're doing and what we're not, what the effect is of what we're doing, what the effect is of what we're not doing. I'd love to see I'd say this parenthetically, I don't know that we can get an exhaustive list, but I'd love to see the things that you lose your direct appeal ability as a result of this, the things that you retain. I just wonder what that is. It's easier to call balls and strikes when you're making policy decisions, and then you take policy decisions and translate those to words, than when you're trying to read words and sort of expand that to what policy is included in it. I'm just wrestling with that.
I'll give you a little bit of my take on that. And of course, Judge McFadden's here, and I hope he'll speak. He's way more of an expert on that. He's an appellate practice expert before he became a Court of Appeals judge. And he could probably answer more directly in the other areas that there's a direct appeal. But if you just kind of get your head around it, at the end of a case, the trial is over. You're not happy with the outcome.
Mm-hmm.
You may always directly appeal that. That's the time when it's a final judgment. This is for something in the fourth inning, let's call it, for your analogy. If you're in midstream, are you going to stop that proceeding and go up to the Court of Appeals and spend 6 months delaying the case? I think the intent is it should be a very significant issue for you to do that.
Sure.
Now, taking your child away from you, or denying you visitation, or changing the terms and conditions of that custody, we have deemed as a matter of public policy, that's a significant enough order or ruling that it ought to be appealable, even if the case isn't totally over. Because your rights to see your child, or to have to pay support from or whatever, they're changed from the time of that order or ruling in the case. And I think that's what we're trying to do. Those significant of issues, you ought to have a right to appeal it directly if you're unhappy or think there's been legal error committed. Everything else, wait till your case is over. And then if it's over and it's a final order, take it up. If not, it better be important to delay the underlying proceedings. That's my take on it. I think that's what we meant to do.
Mr. Atwood.
I could add, Mr. Chairman, essentially what the author of this said, it is simply judicial economy. It's judicial economy, because if not, you'll have frivolous things thrown out there in appeals and delay of the trial, and it is good bill.
Mr. Strickland.
I just had one follow-up. You mentioned this would also apply to child custody changes. I mean, not child custody, child support changes as well. And I'm not seeing where this section actually covered child support.
Again, Judge McFadden might can clarify. I believe that support is part of the custody issue.
Part of custody? Okay.
Visitation support.
Is that by statute or by case law?
I think it's by case law. If I'm incorrect, I think the judge will straighten me out.
Okay. Do you know, I mean, we'll ask Judge McFadden this, but do you know if that is set out anywhere in statute?
I do not know.
Okay. further questions for the author? Seeing none, thank you, Senator.
Representative Ramsey will carry the bill if it happens to.
Well, we got to pass it out first.
If it gets approved. I'll slide over in case you need it.
Judge McFadden,
Thank you, Mr. Chairman.
let me ask you to open with the answer. Come on in. And just to get some clarification on Mr. Strickland's question, which I also had about child support and how that its application in this section or not.
I think there is some case law that suggests that support is an element of custody, and that would be the argument. I am not certain.
Okay. That seems to me to be fairly significant. Yeah, let me just glance over to counsel and see if she just happens to remember.
No, I was looking at the code section to see if there was in another paragraph here about child support.
Because I can't imagine that, I mean, actually, let me take that back. I can't imagine that it would not be specifically set out and that it somehow became established case law at some point, and it's just sort of always been that way in heavy bold quotes. But I would just submit to whoever wants to hear and listen in general that those are two fairly distinct, very distinct areas. I think as the General Assembly from both parties would agree, the custody piece and then the support piece, and that appreciate any clarification any members might have. Ms. Ballinger.
I'm not an attorney, but according to my legal counsel, there is a different section on support, and it's now subject to direct appeal since the child support changes that were enacted in 2007.
Thank you.
Thanks.
And that answers our question, Mr. Strickland. Okay. And we interrupted you, Judge McFadden, before you even began. So thanks for joining us, and
thank you, Mr. Chairman.
welcome your comments.
Thank you, Mr. Chairman. I'm accompanied by a couple representatives from the appellate practice section. May they join me up here?
Sure. I see Mr. Jeff Swart with the State Bar Appellate Section, and anyone else y'all want to bring, you can. Okay, welcome.
If I could address Representative Seltzer's questions a little bit. I apologize.
He never gets that, so don't worry.
I'm sure.
You're the first.
Thank you. Throughout the states and the federal system, interlocutory appeals in the middle of a case, are permitted only in very limited circumstances. And there's a very practical reason for that. If you allow the parties to run up and down to the appellate courts at every whip stitch, even a fast court of appeals, and we are a fast court of appeals, we've got a two-term deadline, which, as far as I know, is unique. Even a fast court of appeals is going to slow things down for a year. And the rules for supersedious are a little bit complicated. It's not necessarily, there's absolutely nothing the trial court can do, but with us having jurisdiction, their jurisdiction is going to be confined, and the trial judge is likely to say, I'm just going to lay hands off until it gets back from the appellate courts. So what we're seeing is, in a few cases, particularly aggressive litigants appealing every order that comes down, and basically taking the position, Judge, I want you to recuse, I want every judge in the circuit to recuse, so every order I see, I'm going back up to the Court of Appeals. And we're having oral arguments where the child's best interests do not even get mentioned. Briefs where they don't get to that issue. And trial judges who can't resolve the case, we can't resolve the case because nobody has full control over it. So the decision to say, custody decision, that's a significant and important thing. We're going to have a direct appeal, that makes sense. Covering every whip stitch in any ruling on any custody decision, we think was inadvertent.
Questions for Judge McFadden? Seeing none. Thank you, sir.
Thank you, Mr. Chairman.
Appreciate it. Thank you, gentlemen. I see no one else signed up to speak on SB 204. Is there anyone else in the audience who'd like to be heard on SB 204? Seeing none. What's the pleasure of the committee? Ms. Ballinger makes a motion to do pass SB 204 LC 295572S. Is there a second? Second by Mr. Strickland. Are there any amendments? Seeing none. Any further discussion? Seeing none. All in favor of the lady's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Let me just let members know. There a few bills have been. Thank you, Senator Calvert. There have been a few bills that have been assigned to both subcommittees. I'd ask the subcommittee chairs to please schedule those meetings expeditiously. My sense is that we'll let that process go forward before we go ahead and establish a certain meeting time. I thought maybe Friday morning, maybe Monday afternoon, maybe not, depending on how that process goes, given the fact that we don't come back until Wednesday. Tuesday is really a civil day, even though it's a recess day. Chairman Willard and his subcommittees will traditionally use a Tuesday. We would use a Monday. So let's just, for now, plan on the next meeting being the Wednesday we get back, right? It is Wednesday we get back, right? Whatever next Wednesday is.
Is there Mr. Chairman, can I just real briefly?
Sure.
For the subcommittee too, is there any constraints from a subcommittee hearing tomorrow afternoon? Members, run that out there. We normally just cast these down. They come down from heaven. They beam down and they're on the calendar. Is there any constraints?
I like to think they glide softly down into the into the subcommittee's jurisdiction. All right, let me ask the chairs to go and meet with their membership individually to try to schedule a time, and more importantly, to get a room. Good luck with that. And we'll plan tentatively for the next full committee to be next Wednesday, depending on the developments in the subcommittees. Thank you, and we're adjourned.